All right, Mr. Burns, you're going to take us out of the pleading.
Yes. What I'll try and do, looking at the time, is go through the pleading, trying to deal with both the questions raised by Lord Justice Males and Lord Justice Phillips, and then I'll meld into the amendment, the 4 paragraphs that are criticised in the second part of the appeal, and link back to where those were, what they used to be in the first unamended particular claim. So, starting at the amended particular claim, the first of the paragraphs that we rely on in answer to your questions is paragraph 41, which is at page 84 in the bundle. That, as it was originally pleaded, unbeknownst to the claimant, instructions were provided to the United States attorneys, and that's Mr. McAllister, who comes back later in the story, Mr. McAllister, who's warned by Rouse that the claimant's complaining about the registration of the trademark in the name of Holdings and not GT. Following correspondence between legal representatives, instructions are provided to US United States attorneys via Mark Foreman to prepare assignments of trademarks and the entire business of GT to Holdings. Just to show you that that is in part not contentious, if one just turns briefly to the defence at page 173, you'll see that that is accepted by Rouse at paragraphs 54 and 55, and they have the dates. It's the 20th of March 2012 when Rouse informed, and OGRP is the Olmert, Greenlee, Regergo and Pearl LLP. They're the US trademark attorneys of whom Mr. McAllister is one of the lawyers. So Rouse informed them and RNA, who are another of the overseas agents, in this case Rajan Narula Associates, who are the Indian representatives, that Rouse had received instructions from its client, that's GT, to record assignments from GT to Holdings of the India marks and the US marks, and requested that they prepare and provide appropriate assignment documentation. 55, Rouse admits that the US attorneys emailed them explaining that due to restrictive US trademark laws, it's necessary for the assignee to be a successor to the applicant's business or portion of, in order to avoid challenge. From that email, MF discussed the position with them and explained his understanding that Holdings was a successor to GT's business on the basis of his understanding that Holdings was the holding company for the joint venture. And just while we're on that page, just paragraph 58, on the 21st of March, he emailed the US attorneys confirming the instruction for them to prepare the assignment. So that's the instruction of the US.
I understood Mr. Stewart to tell us orally today that that was a mistake.
He did, yes, a mistake. I think he was saying a mistake on the part of Rouse.
Yes.
Sorry. Going back to, well, perhaps we should just look at the dates while we're in the defence, so I don't leave it. You can see if you turn on to page 178, the timeline is that Mr. Baines emailed Rouse attaching the executed copies of the UK assignment, the US assignment, the India assignment and the others on the 16th of April. So the instructions went from Rouse to various overseas agents in March, and the executed documents, which include, we say, the documents which have the forged signature on, were in Rouse's hand and indeed the conspiracy defendant's hands in mid-April 2012. Going back to the original amended particular claim, page 85, what did the conspiracy defendants do next? Well, it was originally pleaded that in April 2012, paragraph 47, they contacted Mr. Machado, who's the US potential purchaser of the product, and threatened him. And what did they say? Well, it's pleaded that they falsely represented to him that Holdings held the sale and distribution rights and the brand rights to Geo-Minerals, when this was not the case and knowing it to be false. Well, they knew it to be false, but they had, in April, either, I don't know when it was in April, but at some time in April, they had the actual documents, and they knew that the documents were being prepared by Rouse and other overseas trademark attorneys on their instructions. Therefore, the counterfactual here is that, well, I'll come back to that in a moment. Let's look at paragraph 56. This is something that my clients sitting behind me were keen to emphasise, and I'll just deal with it now because it comes into this part of the story, that in paragraph 56, you can see that in the original pleading, it was pleaded that in on the 22nd of August 2012, their solicitors wrote to Rouse indicating that 2 UK marks, which are listed at the bottom of that page, were in the name of GT, and over the page, 88, we're instructed that you've now been engaged by a company, Geo-Minerals Holdings Ltd, who seek to have the above trademarks, that's the 2 UK trademarks, registered to their name. So the claimant knew in August only that Holdings was seeking to have 2 UK marks registered in its name. Not the whole balloon had not gone up at that stage. They didn't know about the assignments. They didn't know that the whole business had been transferred in the US document, and they didn't know at that stage about the forgery. How did they find out about it? On our case, page 89, paragraph 62, on the 30th of November 2012, Rouse enclosed copies of a number of the purported assignments. Each assignment held the signature of Mr. Gormley as a director on behalf of GT, ostensibly assigning trademark rights to Holdings. That's the 30th of November. And then over the page on page 90, you'll see that paragraph 66, attached to the letter from Rouse on the 17th of January, was a purported global assignment of the entire business of GT to Holdings. The document contained a number of obvious errors, not least the misspelling of MG's name as Gormley. So what's said in defence of the causation claim is, well, you knew by August 2012 that there was fake assignments and you didn't do anything about it. The answer to that is that we knew that Holdings were applying for the UK trademarks to be registered in their name in August. We didn't know about the fake assignments until they were sent to us by Rouse in November, end of November. And we didn't know about the fake assignment of the whole business of GT to Holdings until January. And January 2013 was when, as you might have seen by that time, loss, we say, had occurred. The sales that we had in the wings for 2012 and 2013 have been scared away.
When you saw that all this had happened and signatures had been forged, what did you do about it?
It was at that stage that the Northern Ireland proceedings were taken by the conspiracy defendants effectively in order to try and tie us up, because they took the preemptive strike effectively, and my clients were not in the Northern Ireland proceedings because it was GCL, it was the owner of the quarry, who was sued by the co-defendants, the conspiracy defendants in Northern Ireland, for a declaration that there was a joint venture which held property to the quarry, and that was where the
Doesn't sound like an answer to my question. Why didn't your clients do something?
Well, to a certain extent, there was first there was the fact of until January 2013, as I understand it, it wasn't clear to them what had happened. It became clear to them after. Rouse, although their trademark attorneys had not given information freely to their new solicitors about what had happened, and indeed, I think it said that there wasn't a file. So the new solicitors weren't quite able to understand what on earth had happened, how it was that Rouse apparently had acted for both GT and then for Holdings, who had taken the business away from them. There was also then, as a result of the Northern Line proceedings, the matter of impecuniosity, because effectively the value in the GT, value they had, the assets of that company, were the ability to sell the product.
Presumably you wrote to the trademark registry and said...
There were steps taken after that time to get the trademarks, indeed, re-registered.
And did that happen?
Can I double check that, because I'm not sure I know off the top of my head. Can I get some? I think I might say a bit more. I think it was complicated, and the difficulty was that. No, I won't assume. I'll get some better instructions, and I can ask that question.
Sorry, yes, thank you. It may all be irrelevant to these issues, but it's just
certainly isn't something I have focused on for today's purposes.
Yes, thank you.
Now, paragraph 67 on page 90 was where we indicate, contrary to what Mr. Stewart told you, that Rouse were aware, we plead in the original pleading that Rouse were aware of the true situation. This isn't a new matter in the amended pleading, it was there in the original. Paragraph 67, Rouse did not advise or seek instructions from the claimant or others prior to drafting the assignment documents. Rouse was fully aware that GT was a separate entity to Holdings. So the knowledge of Rouse as the true state of affairs that is criticised by Mr. Stewart as being new is here in the original. Second, 68, Rouse was aware, or ought to have been aware, that GT had only ever instructed it to register trademarks in the name of GT. There was no instructions to register in the name of Holdings. There was a temporary registration in the name of Draven. The temporary registration, as a result of the apparent dormancy of GT, was effected by Rouse without reference to the claimant. So the claimant had only ever instructed it to register trademarks in its name, nobody else's, not Holdings, not Draven. They provided no instructions to assign trademarks to Holdings. The drafting of the assignment documents was out without their express authority, and Mr. Downing was not authorised. So, looking at the counterfactual here, what would have happened, what's the implicit pleading as to what would have happened had the negligence not taken place? The negligence is you, and the breach of duty is, you did this without instructions. The counterfactual is any competent trademark attorney takes instructions from its client, GT, and GT would of course have said, no, you can't register the trademarks or the entire business in the name of Holdings. We've just fallen out with them. They're not our friends anymore. They wanted to do business with us, and they didn't come up with the money during the 90 days of the agreement that we had with them. So the causation in the original pleading effectively is by pleading what Rouse should have done, and Rouse did not do, or alternatively what they did that they shouldn't have done, that is an implicit pleading of what the counterfactual is, of what any non-negligent solicitor or trademark attorney would have done. And if the non-negligent solicitor or trademark attorney had not done that, then the loss would not have occurred, because there would have not have been, the trademarks wouldn't have been in the hands of holdings. They wouldn't have been able to do what they did. That's taken further at paragraph 79 in the breach section, page 94. Paragraph 79, no authority or instructions provided to register trademarks in the name of anybody else apart from GT. The counterfactual, any non-negligent professional would have got authority or instructions. Paragraph 80 was the pleading that GT was the client of Rouse, which is accepted. Paragraph 81, Rouse acted beyond the scope of its instructions. Once again, the counterfactual is that any other non-negligent trademark attorney would have acted within the scope of its instructions and wouldn't have done, so the transfer wouldn't have taken place. And that's the same for paragraph 82 in relation to the entire business. That's the position in relation to paragraph 83, the transfer of the trademark and the intellectual property rights. Then we have the paragraph 84. Again, Rouse was aware, so actual knowledge, or ought to have been aware that GT hadn't provided authority. So that's, again, nothing new about saying that they knew that who their client was, that they knew that there was a conflict of interest when they were asked by holdings to do something, unless, of course, Rouse makes good on its defence that there was a joint venture. And then 85 and 86 are effectively the wrap-up breaches of duty. The duty to act within the scope of instruction, the duty to perform with a professional standard of skill and care, and 86 is the breach. For the reasons outlined in those paragraphs, it acted beyond the scope, it breached the terms of the contractual retainer, it failed to act with reasonable care and skill. Again, what's the causation? The causation is paragraph 87, that exactly what I've just been describing, the breach of authority, breach of contractual retainer, breach of common law, contractual duties of skill and care, have caused loss and damage to the first claimant. So the pleading of causation in the first draft is done in that way. As I say, a very usual way of doing it. The way it's done in the re-amended draft, if you go to paragraph, page 125, there's the pleading as they were before, renumbered from paragraph 101. There's the replacement of the solicitor's retainer with the trademark attorney's duties, which are the same but are expressed in different ways because they're under the Trademark Code of Conduct rather than a solicitor's duty of reasonable care and skill.
You still allege that they're solicitors, though?
That should be taken out. Rouse are solicitors, but Mr. Foreman was a trademark attorney, and Rouse was acting. I think this Rouse entity was the trademark attorneys. This Rouse entity wasn't the registered as solicitors, so that there was confusion. Must be said, the claimants assumed that Rouse were solicitors until these amendments.
Paragraph 4 says that they're all firms of solicitors.
Yes, but that's not correct, and we accept that the sole remaining defendant is a trademark attorney rather than. Yes. So that's why we're pleading the TMA Code of Conduct against Rouse, because that's the way in which that duty is particularised.
Yes, I understand.
And then we have the 108, and the paragraphs which are appealed against are page 127, paragraph 108A, which I'll come to in a moment, paragraph 108J, which is on page 129, paragraph 108K, which is a long paragraph with a number of subs, again on page 109, and paragraph 130L. And paragraph 130L is not a... sorry, 108L. And on page 130, paragraph 108L, which you'll see, is not a further particulars, further breaches. It says, as you can see from the beginning, by its actions, i.e. the actions pleaded, not including but not limited to the forged transfer. What did Rouse do? Rouse provided an authoritative public platform for the conspiracy defendants to make representations to third parties that they own the entire business and the actual intellectual property rights. And then we have particulars of the way in which the conspiracy defendants did that, how they used what Rouse had given them in registering these trademarks in the name of holdings, which enabled them to do what they did with Gulf, with Machado, and with others.
And so you said to us this morning that in respect of that phrase, provided an authoritative public platform, that was thought of by yourself and Miss Greenlee. So going back to the original pleading, which paragraphs do you rely on which say factually that sets that up? It provides the basis for it.
The paragraphs I've just articulated, which are the ones which say what Rouse should have done or shouldn't have done, and effectively the implicit counterfactual there is if you hadn't have done that, it couldn't have happened. So effectively, by saying you granted a trademark to, but the amended pleading doesn't expressly say because the co-defendants had trademarks in their name, they had some weight behind the representations they made to the purchasers, scaring them off. That is what's added to the re-amended, saying that expressly. Yes, Ms. Greenlee rightly points out that in the original pleading, the way that this was dealt with effectively was by telling the story of that happening, the authoritative platform being used. For instance, on page 86, paragraph 51, the original pleading told the story of the conspiracy defendants using the authoritative platform technique to threaten Gulf. And I've showed you already the platform where they used it to scare off Mr. Machado.
Pleading's not really there to tell stories, though, are they?
Hence why paragraph 108L is pleaded.
I mean, the whole purpose of pleadings is to identify the allegations so they can be responded to.
Yes. But the test, of course, is not, is it expressly, is not, is it elegant, is it effective, is it efficient, is it the best way of doing it? The test is, looked at as a whole, is the defendant at a loss to understand the case against him? And the story, although not the best way of doing it, does put the defendant, and did, as we saw from the letter that they wrote, they understood.
No, that came from the schedule of loss.
Well, there's the schedule of loss as well.
Where the point is made, I would accept. But I don't speaking for myself, I'm not sure I would have got that point from the amended points of the claim.
If we just turn to the schedule of loss, Mr. Stewart took you to it. It's at page 218 of the supplementary bundle. And we can see that at page, Mr. Stewart didn't take you to paragraph 20, which does talk about Rouse's involvement.
And that's the one which was referred to in the letter from Clyde's, which you took us to.
Indeed. As you'll see that it said in the schedule of loss, what did any US business that attempted to distribute, purchase or do dealings with the claimants or threatened with legal action and injunctive relief, this undermined and soured any particular business relationships. The conspiracy defendants relied on the assignment drafted by the Rouse defendants. And then, secondly, in terms of causation, the Rouse defendants wrote directly to the claimant's web hosting company, advising that there had been an infringement and demanded the website being taken down. The claimants lost its main source of advertising and hindered its ability to do business. So two matters which are now in the main pleading are that what Rouse did enabled the conspiracy defendants to do what they did in relation to the overseas business. What Rouse did deprived the claimant of the opportunity to sell its product, advertise and sell its product via its website. And you'll see that at D, the bottom of page 220, the first, second, third, and ninth, the conspiracy defendants exercised the rights assigned to them by the Rouse defendants and attempted to raise funding with a poor marketing campaign. The only other part of the schedule of loss that I'd just like to draw your attention to that Mr. Stewart didn't is at page 223, and it's in relation to the Machado loss. What's said about the Machado loss on the pleadings, including the schedule of loss, is that in 2012 the claimant had Machado, who wanted to acquire exclusive distribution rights for the US in a 3-year deal. The claimant had been to the US to meet with Machado and his team in person. The deal was 20,000 tonnes twice per annum, $150 per tonne. Following the assignment of the US trademark by the Rouse defendants, the conspiracy defendants liaised with Machado and advised that if he proceeded with the transaction, he would be subject to injunction. This caused huge concern and confusion for Machado, and as such, the 3-year deal never went ahead. And so, once again, here's an express pleading of causation, where what the Rouse defendants did allowed the conspiracy defendants, what Rouse did allowed the conspiracy defendants to go to Machado and tell him that if he proceeded with the transaction, he'd be subject to an injunction. And you saw that was in the timeline at about the same time when Rouse were getting back the executed assignment documents. So Rouse and all the conspiracy defendants had in their hands the documents.
We presume you say that providing an authoritative public platform to routinely make representations isn't new facts, isn't new cause of action. It's actually a categorization or explanation of the causation element.
The 108L is the amendment that we made at Rouse's insistent request. They said this pleading cannot be in various documents, it needs to be in the actual particulars of claim. And so they invited us to amend, and we did. And so we drew together the threads and put that in 108L. That is the amendment that's made at the request of Rouse.
Effectively argument.
Which shouldn't really, in some ways, shouldn't be in the pleading, but frankly, this attempt to try and suffocate the claim by attempting to say again and again that causation isn't properly articulated, just needed to be, well, I say nipped in the bud. It had fully flowered and had withered and grown again by the time we came to this, but effectively, 108L is the amendment that Rouse requested, and yet it's one of the paragraphs which is subject to this appeal, one of the 4 paragraphs that objection is taken to.
In respect of the other 3 paragraphs to which objection is taken, were any of those requested or any part of those requested by Rouse?
No. So I should take you to those next, and we'll do it in turn. What I propose to do is look at each of those paragraphs and ask the question, number 1, is it a new cause of action? Number 2, is it the same or substantially the same facts with regard to whether or not Rouse needs to embark on a new investigation and in consideration of the defence, the test that Mr. Stewart and I agree. What Mr. Stewart didn't do is take you to those 4 paragraphs to which the appeal is directed and look forensically at those 4 paragraphs to see whether or not the test. What he did is he tried to do a wrap-up and kept on giving you an example call made to the Mr. McAllister of the US attorneys in 2012.
Well, Mr. Burns, why don't we do it now?
So I'm going to do it now.
Come on.
Paragraph 108A is the one to start with, and that in your bundle is at page 127. Perhaps I'll just pause to let you look at the exact wording of 108A. The judge said that this was amounted to another instance of how Rouse was said to have provided misleading information to Pritties, and that is it a new cause of action? Well, the duty is the same. The duty is the breach of the contract, the breach of the retainer, the duty of care. The claimant now knows that Rouse were acting as trademark attorneys, not solicitors. But what is said in A is that Rouse, acting outside of its retainer, instructed Pritties to do something which was outside of its instructions. So at its, the law says, and Mr. Stewart and I agree on this, that you look at the amendment, first of all, at facts at its highest abstraction to see if it's a new cause of action or not. The new pleading, in November 2011, Rouse instructed Pritties without instructions from the client in breach of the duty of care and skill. Turn back to page...
Sorry to interrupt. Where does that paragraph go? I don't think we've heard anything else about an NDA with Peter Hambro Limited, and it doesn't seem to have anything to do with the authoritative public platform.
No, the reason it's pleaded, perhaps I'll answer your question by showing you where Pritties, turns out this is the beginning of the story. When we had the amended particular claim, the beginning of Rouse instructing Pritties was pleaded, and it was thought to be early 2012. It turns out it was the end of 2011. I take you to paragraph 32 on page 81. You'll see that what's in the previous claim, and I say this is part of the same cause of action, is that, first of all, on page 81, we can see the Pritties are coming to the story, as far as the claimants know, on the 22nd of March 2012, when Mr. Wayne of Pritties, acting on behalf of Holdings, wrote to the conspiracy defendants and copied Mr. Foreman of Rouse, relaying the offer to Holdings. Turn over the page, page 82, and you'll see that paragraph 31, Rouse emailed Pritty on the 28th of March confirming an instruction to Pritties to draft heads of terms and instructing them that the contracting party wouldn't be GT, it would be Holdings. So the facts that are pleaded are that Rouse was instructing Pritties to act on behalf of Holdings, not its client GT. And then 32 heads of terms were duly drafted by Pritties on the instruction of Mark Foreman of Rouse, and you can see there that it's in relation to a deal between Holdings and CCH. Go back to 108A, and you'll see that 108A is another instance of Rouse breaching the contract. It's just the beginning of the engagement of Pritties, which in the original pleading was thought to be them engaging Pritties to do things in relation to CCH in early 2012. But actually, the course of conduct by Rouse started with them purporting to act on behalf of GT, but doing the the same thing.
But no loss is said to flow from the NDA or draft NDA
No.
with Peter Hambro, is there? So
No, this isn't something that causes separate head of
I don't
loss.
know what this is doing, this paragraph.
It pleads the beginning of the breach involving Rouse's instructions to Pritties to act on behalf of Holdings rather than on behalf of its client. Is it a new cause of action? I say no. The cases say that a further instance of a breach is not a new cause of action. And in any event, does it arise out of the same or substantially the same facts? This arises out of Rouse instructing Pritties, the end of 2011, beginning of 2012, to act for GT and Holdings as if they were the same entity.
So the essence is, as I understand it, but correct me, that what you're alleging is a course of conduct, and this is an earlier instance of
Early
it.
instance. And the cases say, on the question of whether it's substantially or the same facts, same or substantially the same facts, the question in the authorities is it completely, quote, completely outside the ambit and unrelated to the facts in the early pleading? So it's quite a high threshold. It needs to be completely unrelated. And I say that this is closely related to what was pleaded around Pritties before. It's the same broad circumstances, closely related to the facts previously pleaded. Does it need to embark on new investigation? No, because Rouse have already investigated its instruction of Pritties at this time. If there is any new investigation, it's going to be a very limited extent. It's going to be looking at whether what they did in November 2011 rather than the beginning of 2012. You can see from the defence at page 172 that Rouse have already investigated this. And the question, of course, for you is, you're allowed to consider the defence in order to answer the question, is this the same or substantially the same facts? Is there a need to embark upon a new investigation? What Rouse have said at page 172, paragraph 41, is that on 7th of March 2012, Mr. Bloor of Pritties Solicitors, which Mr. Foreman of Rouse understood was acting for the joint venture, emailed Mr. Foreman with the draft heads in respect to a proposed exclusive US distribution deal. Contracting party in the draft Machado heads of terms with GT, having discussed the draft Machado heads of terms with the conspiracy defendants, Mr. Foreman provided Pritties with comments, including providing the details of Holdings as the contracting party in the draft Machado heads of terms. And then it goes on to paragraph, page 174, paragraphs 59 onwards, we have the course of dealing between Pritties and Mr. Foreman of Rouse at the beginning of 2012, where Pritties, they say, was understood to be acting for Holdings. Look at 59.3, looking at 61.1. So there's a course of conduct where Rouse is telling Pritties that the contracting party is Holdings and not GT. And so, in my submission, this is not. This is the same or substantially the same facts. They've already investigated. They've already pleaded to pass this course of conduct, and this is a further instance. Another of the expressions used in the case law. You have to look at whether this is a further instance of the same cause of action. So that's 108A. The next one, 108B through to I, are not subject to appeal. The next one is subject to appeal is 108J. That Rouse repeatedly failed to communicate its knowledge of actions taken to the detriment of its client GT. I should have said, and I didn't, in relation to 108A, haven't quite understood Mr. Stewart's point about an intentional breach of contract. because intention is no part of breach of contract. It doesn't need intention. It doesn't matter whether it's a deliberate breach of contract or an accidental. In some ways, every breach of contract is a deliberate breach of contract because somebody does the act which breaches the contract. But unlike some torts where intention is a constituent element of the cause of action, intention or deliberation is not a constituent part of the... so the suggestion by Mr. Stewart that the case law about fraud, pleading fraud instead of breach of contract, is, in my submission, irrelevant, because we're not pleading anything different from that before. As I said when I rudely stood up and interrupted, we're relying on negligence and breach of contract only in the original pleading and in the amended pleading.
Well, why do you plead it? Why do you plead it then?
We plead not that the breach was knowing. If you look at paragraph 108, you'll see in breach, it's very conventional. In breach of their contractual retainer, they did the following. What we're pleading they knew was that paragraph 108A, Rouse knew that Mr. Downing was not a director of GT. They knew that the conspiracy defendants were not shareholders of GT. That's why it was negligent and or in breach of duty for them to say that they were. They knew that. It was on their file. And when they were talking to third parties, they should have had that in the front of their mind. And they didn't. And that was a serious breach of care and skill. You'll see also paragraph 108J, top of page 129. That contains, as was discussed this morning, an element of causation, because the counterfactual is in there. Had Rouse alerted GT to the actions of the conspiracy defendants, it would have taken steps to prevent the fraud. If it had known about what Rouse was doing in April 2012, then the whole thing could have been scotched before any of the purchases were lost. So is this, again, is this new? Is this a new cause of action? Paragraph 85 on page 95 is the very broad precursor to this. I accept 85 and 86. There's a general pleading of the duty to act with reasonable care and skill. And this failure to communicate with its client is, in my submission, a particular of what a trademark attorney does if they're acting with reasonable care and skill and they're following their contractual retainer. If they're acting with reasonable care and skill and following their contractual retainer, they communicate its actions to its client. And if there's a problem, it tells the client. And if it's created a conflict of interest, if it knows there's a conflict of interest, it tells the client straight away. Now, Rouse knew there was a conflict of interest between Holdings and GT and should have told the client. And failure to tell the client is a breach of the same contractual tortious duty that was pleaded in paragraph 86. This is a particular of that. So it's not a new cause of action. Is it same or substantially the same facts? Well, it's exactly the same facts, just a new label. Plainly, Rouse should have informed and alerted its client the conflict of interest. This is a more precise label put on the breach of duty, particularly so it fits in with the trademark attorney's code. It's a more precise label put on it so that causation is more obvious. So I suppose in relation to Milady's question, are any of the other paragraphs the ones requested by Rouse? But I could say in relation to J, well, yes, we're trying to give a particular which explains the causation case more clearly. And we add that last line, which is purely about causation. So although it perhaps wasn't what Rouse had wanted to hear, it was us responding to their requests to plead the causation case in one place. you've seen already in the defence, I've taken to the parts that Rouse already plead that it did have authority to act on behalf of holdings. There wasn't a conflict of interest because they say there was this joint venture which allowed it to do so. The belief in the joint venture is their defence. So they've already pleaded to this. No new investigation needed.
You can't be instructed by a joint venture, can you? You can be instructed by a joint venture company, maybe.
Well, you have to be instructed, yes, indeed. You have to be instructed by one of the partners in the joint venture. And, well, we'll be arguing at trial as to whether or not actually a professional's duty is to make sure that both parties in the joint venture are on board in relation to each part that's put forward.
Well, you can only be instructed by a partner, or joint venture, if it's a partnership.
Yes. It would depend on the nature of the agreement that gave rise to the joint venture. Which Rouse presently pleads is an all arrangement.
Well, between a number of parties.
Including Davies. Davies,
Including.
but not including holdings. They plead it's a joint venture between Davies, conspiracy defendants, GT. Paragraph 108K is the next one that is subject to this appeal. Once again, if I just pause there just to let you look at 108K and its 6 sub-paragraphs.
And you accept, I think, that the words including but not limited to should not be there.
Indeed, I accepted that in front of the judge, or that they didn't mean anything other than what I said before the judge was you can't open the gates to anything. You have to plead what you want to rely on. And they should have been excised from the revised, tidied up version. And I'm slightly embarrassed to see that they haven't. That's my fault.
All right, so taking that first line in K, Rouse actively sought to advance the interests of KD, CD and RJB to the detriment of GT and in conflict of interest. Where do you say that is shadowed in the original pleading? Are you saying that comes within the ambit of 85?
Yes, because this is a particular.
In the same way that J is a particular.
Indeed. Because effectively they're saying, well, in what way did a breach of contract, a breach of duty, negligence cause loss to us? So we give these 6 examples of where what they did resulted in loss. So, for instance, the instruction of Prittis to replace GT with holdings in the draft Machado heads of terms, March 2012, removes the claimant's opportunity to make profit out of the Machado deal.
Can we try and be a bit more precise? If we look at 85 and 86 of the original pleading,
Yes.
it can't be a particular of 85 because
No,
85
it's
pleads
the
the duty, not
Yes.
the breach. 86 pleads the breach, but the breaches are for the reasons outlined above.
Yes.
So where in the outline might be a bit euphemistic actually, but where in the above do we find these allegations or something like
So the in the sections above, well, can I take these in turn between all 1 to 6, if I can? First of all, we look at it at the highest level of abstraction. So the breach in this case is acting in conflict of interest to the claimant, and the unamended pleading talks about the client being GT, paragraph 80, paragraph 81, Rouse acting beyond the scope of its instructions by arranging the transfer to holdings where there was no authority and execution of other documents and the assignments and assigning the valuable trademarks, 84. So effectively what we have is this is another instance of where Rouse, acting in conflict of interest to its client, does something without the authority of its client to the benefit of holdings. In this case, it's the assignment of the Machado heads of terms to holdings, whereas in the instances given before, it's the assignment of intellectual property rights, business of GT, trademarks of GT, other property rights to GT. Now, I accept, and the reason for the amendment is that saying that in breach, Rouse assigned property rights, or purported to assign property rights from GT to holdings, or assigned business from GT to holdings, it lacks particularity. And therefore, it's important to give particulars. And in this case, the particulars are that the property rights, or the part of the business that was purported to be assigned from GT to holdings, was, well, in number 1, the draft Machado heads of terms. Number 2, it's effectively an act in support of the transfer of the US trademarks, because this is Rouse saying to the US trademark attorney who had acted for GT in assigning the trademark to holdings that they may receive communication from the claimants disputing the transfer. Number 3 is also relating to that. Number 4 is relating to the other overseas agents, which are the Chinese and the Indian ones. Number 5 is and 6 are the websites. So effectively things that GT owned, its property rights or its business rights, were being lost by virtue of Rouse's breach. And in the original pleading, that was pleaded in very general terms. And this paragraph is there to give the particulars that were required, particularly as the particulars shouldn't appear in the correspondence. They need to appear in the pleadings. And Rouse's points about that were well made. So, is this something that is the same or substantially the same facts as before? Well, I say it's details and specifics, it's more particulars of what was given at the highest level, and it's not completely outside the ambit and unrelated to the facts. And in this particular case, 108K, it is very instructive to look at what the case law says about how to investigate the same or substantially the same facts by saying, does the defendant need to embark on a new investigation of facts? Is it something that arises already in the defence? And the remarks about Pritties and the Machado heads of terms, I've taken to that already when we were looking at causation. Already investigated, already in the Rouse defence. The overseas agent, Mr. McAllister, you'll remember I said that Mr. McAllister was one of the agents of the US attorneys who were mentioned and who were called OGRP in the Rouse defence. So once again, the relationship between Rouse and OGRP has been investigated, and the plea is already there in the original pleading that Rouse instructed Mr. McAllister that Holdings was the successor of GT. I showed you that on page 170, you recall, and 173. And this is a further instance of it because later in the timeline, Rouse does the same thing again. He calls up Mr. McAllister of OGRP and tells him something which effectively emphasises that Holdings is the client and not GT. The defence also shows that Rouse has already investigated its relationships and its communications with the other overseas agents. I showed you that before, but perhaps we should just go back and remind the court. It's page 171. There's a section 170 and 171 about the relationships between the US trademark attorneys, the India trademark attorneys and the China ones, which start in late 2011 and go through to 2012. At paragraph US and India, paragraphs 31 to 34, Chinese 46 to 49, the US, Chinese and Indian assignments 50 onwards, and the execution of the US and others 68 onwards. What we have in the pleading is we told the overseas agents that Holdings was the proper client because of the JV. And so what we're now pleading is that Mr. Rouse told Mr. McAllister and the other overseas agents later in 2012 that Holdings was the client and not GT. And so once again, we say it's a later and further instance of the same, substantially the same facts, or the same facts. And in relation to websites, that's dealt with in the defence at page 181. You'll need to look at the amended particular claim together with that, because it's a bare denial. If you have page 89 open and page 181, you'll see that page 89, paragraph 61 has 3 sentences. The first sentence is that Crawford's wrote on behalf of the claimants. The second sentence is that it became apparent that the conspiracy defendants had arranged for the website to be rerouted to Holdings. And the third sentence is that Rouse had written to Paragon instructing it to take down the original Geo-Minerals.co website. Turning back to 181, you'll see that the first 2 sentences in paragraph 84, the first 2 sentences of paragraph 61 are not admitted, and the final sentence is denied. Rouse didn't write in terms, it said to Paragon instructing them to take down the website. Therefore, the particular of the new re-amended particular claim, just go back to it, page 121. Are further instances in October 2012 of Rouse doing something we say that's already been investigated, that Rouse have already pleaded to in relation to Paragon. I don't know whether Paragon is related to Hogs, HostGator and web hosting or not. Whether they're the same company or a different one. So that's 108K. And finally, the last paragraph that is complained about in this appeal is 108L. And I've already really dealt with this. This is the effect of the causation paragraph. So is it a new cause of action? No. by its actions, i.e. the actions that already pleaded. This has happened. There's no new facts, no new investigation of facts. This is just substantially the same facts set out as already set out in the pleading, except the instances of what the conspiracy defendants were able to do are enumerated so that the causation argument is better highlighted. Therefore, that's why I say in those 4 paragraphs, and the way that the grounds of appeal is put is that what is said in the grounds of appeal is that the judge erred in relation to allowing the amendments for those 4 paragraphs and any new factual plea which has been included to support those allegations. So in my submission, what you need to do is look at paragraphs 100, this is paragraph 33 of the grounds on page 31 of the grounds of the grounds appeal skeleton. Grounds of appeal are very short indeed at page 15, as they should be. Ground 2, paragraph 33, the limitation issue is taken specifically in respect of the following paragraphs, A, J, K and L, as well as any of the new factual pleas which have been included in order to support those allegations. And I accept that if this court finds that one of those is a new cause of action that doesn't arise out of the same or substantially the same facts and does require significant new investigation, isn't already addressed in the defence and so forth, then that paragraph would offend against the limitation principle, and any new factual pleas which support it, as long as it didn't support anything else, would fail. But those haven't been identified specifically. It looks as if just those 4 paragraphs which have been the ones that specifically have been identified as the subject of the appeal.
Can I just be clear on what you're saying? If we were to conclude, and I'm not saying we will, but just because you mentioned the point that some of the paragraphs are okay in the sense that they're not a new cause of action or they are substantially the same facts, but one or more of them is a new cause of action and raises new facts, are we supposed to allow some in and some go out? The judge was presented with all or nothing, didn't he?
No.
Yeah?
The judge, in his judgment, decided that they all, all 4 of these fell within the same cause of action for the reasons I've just been submitting, and he found that they alternatively fell within the same or substantially the same facts. He dealt with it in very shortly, but when we were arguing, of course, we went through the allegations in turn, as I've just done, as you must do, because the question is on each of them.
I was just wondering how granular we're supposed to be. Do we go through paragraph by paragraph, or sentence by sentence, or chop out a word here or there?
Certainly in the authorities, it's paragraph by paragraph, is the way that the case we looked at. I think that I would accept that 108A is one allegation, 108J is one allegation, but obviously 108K is there's the general allegation that they acted in conflict of interest. But if it was thought that 4, 5 and 6, for instance, had not been raised before and were completely outside the ambit of the facts that were raised before, then those would fall away, and 1, 2 and 3, which weren't completely outside the ambit of what was there before, would stay.
Okay,
And the same
that's your position. Thank you very much.
Yes. If, in terms of the appeal threshold, that's dealt with briefly in MasterCard. Perhaps it's just useful just to finish on that. Page 147 of the authorities bundle. what Lord Justice Sales says in that judgment. That's MasterCard and Deutsche Bahn. Paragraph 35, which begins at the bottom of page 146. It deals with the jurisdiction of the court to allow the amendments and the fact that that operates the relation back rule, and then says this at the third line of the page 147. Although it's sometimes said that this is substantially a matter of impression, and that's the Welsh Development Agency case, it was emphasised by Lord Justice Millett in Paragon Finance that while in borderline cases this may be so, in others it must be a question of analysis. See Ballinger. It's clear from Part 17.4.2 itself the condition must be satisfied before permission to amend can be granted in a case to which it applies. In some cases, that may involve an evaluative judgment by the court, in which it's possible to say that there's more than one answer which could rationally be given on the point, and in relation to which it could not be said of any of those answers on appeal that it was wrong. Such an appeal should be allowed. CPR 52. In other cases, the issue may be more clear-cut and admit of a single answer which is right, so that if a different answer is given by a judge, it can readily be said on appeal to be wrong. In both sorts of cases, it is strictly a matter of analysis whether the judge has made the proper or acceptable evaluation on the question of whether the condition has been satisfied. And the condition is it a new cause of action? Is it same or substantially the same facts? Looking at, does it need to be investigated afresh? Is it completely outside the ambit? Is there any mention of defence? But I say, at best, what Mr. Stewart raises with you are differences around edges. This is, in my submission, at best, a borderline case, because all of the matters that we've been dealing with are somewhere, to some extent, in the original pleading. And so in this case, it may well be that on that borderline, this is one of those cases where different judges can come to different decisions about whether or not this is the same or completely different. In which case, some deference, of course, must be given to is on Judge Bird's assessment of it, as well as this court's. Unless you have any submissions or questions for on my submissions.
Thank you very much indeed.
Oh, one thing. Did you track down the mediation letter?
Yes, we did, and it's less clear cut than I thought. I had perhaps a little prejudicially assumed that it fell through for the reasons I said, and Mr. Stewart has pointed out that there was another problem in that the conspiracy defendants, who of course need to be involved in any overall mediated settlement, one of them suffered a heart attack in the early part of last autumn, which I'd forgotten about, and requested a postponement to the originally planned mediation, not the Court of Appeal mediation. And then there was exchange of letters, which I think all the parties thought that this wasn't a case that would properly fall within the Court of Appeal scheme. I think Mr. Stewart's got the hopefully that summarises it.
All right, well, if we're going to get there at some point, that's very helpful.
Are you both content for us to receive those letters?
The letters I'm proposing to hand up are open letters which were sent, I was going to say to the court, they weren't actually, they were sent to the Court of Appeal mediation scheme, but they're open letters, so there's no difficulty about that. I've had a brief discussion, and I don't think anything I'm going to say is going to trespass on mediation privilege. For reasons I'll indicate very briefly, if I may, I do want to say something very briefly in response to both what my own friend has just said and the court's question.
Thank you very much indeed, Mr. Burns. Mr. Stewart.
Shall I just deal with that
yes,
first?
do. Thank you.
Just hand up those 3 letters. The reason I rise is that my Lord raised directly the question of the Court of Appeal mediation scheme, and my learned friend referred in his answer to a suggestion that a mediation had, as it were, been on the cards and had ploughed into the sand because of the grant of permission to appeal. But factually, I think there is no dispute between the parties that there were discussions between, I say, all 3 parties to the action, by that I mean my clients, the claimants, and the conspiracy defendants being collectively. which were ongoing last autumn. There was then a stay for mediation which took place. As my learned friend has just said, one of the conspiracy defendants had a serious health problem and requested an extension to the stay. There were difficulties about that, not from our clients, if I can put it that way. And the mediation then, that mediation then came to an end. As far as we're concerned, there was no linkage between that and the grant of permission to appeal, and that's what I wanted to say in relation to that. Separately, we received the letter which you get from the Court of Appeal mediation scheme following the point which my Lord Justice Males had made. And on looking at it, it appeared to us that we didn't qualify, and we wrote accordingly in the letter which is on the first, or the email which is on the first page before you, to the CEDA, and that was agreed on the 5th of December by the claimant. So that was the agreed position. I think that's as much as I can say in relation to
All right, well that's very helpful because, as you might imagine, these recommendations are not just made for fun, and the court is interested when mediation has been recommended or something appears to be within the scheme and that is marked on the permission to appeal form, to know that that is properly followed up. So I'm grateful to you for clarifying.
Well, I think anything more I said on that is liable to get.
No, you mustn't do that.
But I hope that
I'm not seeking to probe.
What I would say, my Lord, is you can be satisfied that all parties, including the conspiracy defendants, have been giving very active consideration to mediation. That's the position.
Thank you.
Nicola wants to say something.
I should have said at the close that I haven't addressed ground 3 on the basis it's purely parasitic on ground 1 and 2. And Mr. Stewart took the same line, but that's why I haven't taken to ground 3.
Thank you,
Apologies.
Mr. Thomas.
I will briefly address, by way of reply, the points which my learned friend made. Can I just preface my remarks, because I'm going to show you some documents which run rather across what my learned friend has been saying, by making the point that particularly in an action of this sort, where many millions of pounds are staked, pleadings are not a pick and mix variety, where one has a variety of different possible angles which one can choose on particular occasions to draw down and take advantage of. And it will become apparent why I say that. One of the central purposes of pleadings is not just, as my learned friend said at one point, to allow a party to plead to allegations, but to know the case that it has to meet in relation to the full preparation of a matter for trial. None of this is anything other than basic stuff, but particularly, if I may say so, when the allegations relate back many years, when there's been every opportunity to clarify positions, and where, on any view, many millions of pounds are being claimed on the face of it. Quite how many millions is not apparent, but there are many millions of pounds, depending on which versions of the various schedules of loss you look at. I'm going to pick up the points in the order they were made. My learned friend said that in the defence of the conspiracy defendants, there is no reference to the existence or otherwise of a joint venture, and that's in contrast to the position in Northern Ireland where there were detailed allegations pleaded. That is A, irrelevant, but B, factually wrong in relation to the defence of the conspiracy defendants. You have the defence of the conspiracy defendants here at page 12, tab 12 of the core bundle. And if you go to paragraph 39 on page 202, you get pleaded that by October 2011, KD, CD and CT and NG on behalf had agreed the terms of a joint venture agreement which superseded and or replaced the October 2011 agreement, and there are terms pleaded in relation to it. That is referred to throughout the existence of the defence. I don't need to go to it now. The learned friend took that point avowedly as a jury point, saying that the purpose of this application is to avoid a trial. Well, that can be tested, frankly, quite easily in this way. First, if my learned friend wanted to make an application for summary judgment and so forth, he can do so. No such application has been made. But secondly, and more materially, suppose it were the case that there were in fact admissions on the existing breaches of contract in the original pleading. That would not, absent a case on causation, entitle them to judgment, and it wouldn't entitle them to add in additional new causes of action after the limitation period. So it really takes the matter no further forward. There is no application for judgment and so forth, but in any event, it takes the matter no further forward. The clarity of where we are in relation to the schedule of loss, and the question as to whether or not the schedule of loss is or is not part of the case which is being put forward. My Lord Justice Mayles assumed that it had been superseded. My learned friend said that it was still part of the case. In addition,
I thought he said it was superseded.
sorry,
He
my Lord,
accepted what I said.
my learned friend said it had also been superseded. His pleadings, and I'll show you in a minute, say after the matter before the judge, it's still part of the pleaded case. And I'll show you that in a minute. I'm also going to show you a matter which we regard as being of really quite considerable importance. The way that my learned friend addressed you in oral argument this afternoon on one of the critical paragraphs in issue 108L is that paragraph at the end of the particulars of breach is effectively how he described it as being his response to our request for particulars of causation. In answer to my lady's question, when my lady said, well, is there anything else which we'd requested, he said, no, they didn't ask for anything else, but they did ask for that. So he's putting it forward as the case in relation to causation. That is diametrically opposed to how it was put forward before the judge in skeleton arguments, in oral argument. It's not in his skeleton argument for the purposes of this appeal, and it's directly contrary to the pleading which has been served after the judge's judgment, when we've sought to clarify and understand what the case is.
That's the pleading we've got at divider 10.
That's the pleading that we've got at divider 10, of which we asked for some further information. Now, if I, having promised you not to go there, if we could go, please, to the revised, re-amended particulars of claim, and one looks at how this matter is put forward, and go, please, to page 156. This is all in black, but what you will see at 107 is particulars with which you are now familiar, which go from 107 little a through until 107 little k. And then what used to be 108 little l, which of course in the draft before the judge was introduced by the rubric at the start of 107 in breach of their contractual retainer, duty of care, etc., is stripped out and put as a separate paragraph. And so we thought, right, okay, so that's their case in relation to causation. And we asked for further information about that. And the further information is to be found in the supplementary bundle index, and which was served as recently as March of this year, and it's the very last tab in the bundle. It's tab 56. The first question goes to the status of the schedule of loss. And we asked, please confirm which part, if any, of the initial response, the revised response and the statement of loss remain part of the claimant's pleaded case.
Sorry, I've not caught up there.
Tab 56, my lord.
56.
Page 288 of the supplementary bundle. It's the last document in the supplementary bundle.
Page 56 by mistake. Thank you very much.
And we asked which parts of the initial response, that's the first response to the RFI, the revised response, that's the one which was served with the schedule of loss in February, and the statement of loss, that's the one which was served in February 2020, remain part of the pleaded case. And the answer was the revised response was served to revise and update the initial response. The revised re-amended particulars remain the claimant's pleaded case, and to the extent there are any differences, for example, holding no longer being a defendant, the revised or amended particulars claim supersedes the response. The schedule of loss remains part of the claimant's case on loss, except where there are differences mentioned as above, but will be updated in accordance with the court's directions. And in relation to the 107, which has become 108, on page 293, so this is a question which is in effect in relation to what was 107L before the judge. And of 108, clarify whether this paragraph is intended to constitute an allegation of breach of duty, and if so, say what duty is alleged to be breached and how. If this paragraph is not intended to constitute an allegation of breach of duty, explain what its purpose and relevance is, confirm what any other actions of RACL will be relied on, etc. And then answer yes, in breach of their contractual retainer duty to act with reasonable kill and scare having regard to the TMA conduct. So it's confirming that this is a case on breach, and it's then said that it's not applicable in the relation to it not being an allegation of breach of duty. So with respect, the idea that 108L in the formulation before the judge and what's the subject of the appeal is the answer to the case on causation is not sustainable by reference to what is now said. It's also not sustainable by reference to how the matter was put before the judge and how indeed the judge understood it as a result of that. There were two skeleton arguments served by my learned friends before the judge. They're in the supplementary bundle, and the first of them, which is the main one, is at 148. And this skeleton argument was served on the 16th of March of 2022. That's before the first of two hearings. It was a hearing before the district judge where there was insufficient time to deal with all matters, and she dealt only with getting rid of some peripheral matters, and then the matter was adjourned for a hearing before His Honour Judge Bird. So this skeleton was the skeleton in relation to that. And if you go to what is said as to the relevant matters in this, you see the description of what 107 little l is meant to deal with at page 148. And 28 provides a summary as to how the Rouse defendants can better understand, investigate the case against them. And little I says further particulars of the breach of Rouse duties to the claimants, paragraphs 101 to 108, detailed particulars of the unlawful acts of the Rouse defendants which caused or contributed to the claimant's loss, C, e.g. paragraphs 108K and L. So they're described as being the particulars of breach. It's not asserted in this skeleton argument that 108L is where we look for the findings in relation to causation. The judge, unsurprisingly, understood this if one looks at the judgment on page 59 and looks at paragraph 28D. He summarises the amendments as falling into 4 categories, and he summarises amendments to the way causation is pleaded as 100 and 110, and then D, amendments to the nature of the duty owed by Rouse and the allegations of breach against Rouse at paragraphs 101, 102 and 149, respect of the loss and damage suffered by GT, etc. So, with respect to my learned friend, the idea that you can now look at 108L and say, there you are, that's all you need to know in relation to causation, that's what you've been asking for, it is not sustainable on the history of the matter. It's inconsistent with the way that it's been presented consistently beforehand. But more materially, if that is what is now sought to be relied on, it includes a whole series of new factual allegations. We objected to 108L, and we've always objected to 108L on the grounds that have been put forward. And it therefore, as it were, as the kernel of the case, sets out, we would say, a new and impermissible case in relation to causation. So whichever way my learned friend looks at the matter, we say that he hasn't got, in his particulars, a sustainable case in relation to causation. The Lord,
forgive me. Are you saying then that you object to that on limitation grounds? Because if we do, we can't just say that's a case on causation. That new case on causation, you've got to look at it in terms of cause of action.
Yeah, you have, my lord. You have. We just to answer your question directly, yes is the direct answer to your question. We've always objected to 108L is always one of the matters that we have objected to. We object to it whether it's particulars of breach, which is what it looks as if it is and what it's been confirmed to be. But we also object to it if, contrary to that, and is now put forward by our own friend, it's a case in relation to causation. So that's what I was trying to say when I said whichever way we object to it. Now, sorry, Noel, I didn't interrupt you.
No. I'm just trying to understand, though, because my understanding, the limitation objection is that there are new causes of action pleaded, which are not substantially the same as those which were pleaded already. I'm not quite sure how that meshes together. If it's a new formulation of a causation case in relation to existing causes of action.
My Lord, I was thinking about your Lordship's question this morning in relation to the decision of the Court of Appeal in Beeman and Arts, and could I just make this observation? Cause of action is one of those terms which lawyers, probably without realising it, use in different ways in slightly different contexts. So, have you got a cause of action in breach of contract? Yes. Have you got a cause of action in negligence or breach of fiduciary duty or any of the other for conversion or anything of that nature? In the context of limitation, that is, in my submission, slightly misleading, because if one goes back to any of the classic formulations of what is meant by cause of action, it's not enough to say, well, it's a claim for breach of contract. It's a set of facts which entitle you to relief. And so actually, I slightly skipped over it, but the building contracts may provide some assistance in this context. The cases, I was going to say full, but there are a number of cases where you have Party A and Party B who have a building contract, and that building contract is to build a university, or whatever it happens to be. And the client sues the builder for defective flooring. And then after the limitation period, obviously, he comes along and says, I want to add a case in relation to the roof. Now, the cases do say in that context it's a question of fact and degree. But on the example I have given, it would be clear that if there's no other connection between the roof and the floor, that's a new cause of action. The fact it's a breach of contract, it's of the same contract with the same date. And the reason it's a new cause of action is because it's a new set of facts. And the new set of facts are different, both as to what the breaches are. You've breached possibly the same duty in relation to the construction of the floor and the construction of the roof, and it gives rise to different sets of damages. The cost of repairing the roof is X, and the cost of repairing the floor is. Now, there are particular problems in the context of building cases, because what you very often used to get, and you do still get to an extent, is a generally endorsed writ or claim form, and then a narrowing down of issues in an attempt to widen it out, so you get into those problems. But it does, in my submission, illustrate the danger of thinking of cause of action in this context as being a claim for conversion. It's the set of facts which gives rise to relief. And coming back, if I may, to the answer I gave to your lordship this morning, of course, Beeman and Arts was a case. It's one of those classic cases under the 1939 Act, which led to the rise to the well-known saying that for deliberate concealment under the 39 Act, you didn't need either concealment or for it to be deliberate. But what you were looking at there was the question as to whether or not the addition of the word deliberate in relation to conversion added anything. Fraudulent it was, yes. My lord's right. And the Master of the Rolls, Lord Green, said that actually, in the case of concealment, conversion, in the civil context, as opposed to the criminal context, where it's obviously extremely important as to whether it's deliberate or not, fraudulent is nothing more than an offensive epithet. And that's because he's looking at the question as to whether or not conversion is an action based upon fraud for the purposes of the 1939 Limitation Act. In a sense, fine, but that only really takes us so far in relation to the analysis which we have to look at here, where one is looking here at whether or not the allegations made against my clients give rise to a new cause of action. Now, they're put as being breaches of contract, and let's accept that there is a incorporation by a method of the TMA Code of Conduct, and that Code of Conduct includes not having conflicts of interest. The word conflicts of interest is not mentioned in the original statement of claim. So simply saying it's a breach of contract doesn't get you anywhere. You're going from a situation where you're complaining that you didn't give rise to the implied term you didn't give effect to the implied term in relation to the transfer of some particular narrowly delineated assignment documents, and they are defined in the original statement of claim. They are the ones which I identify, which are all trademarks, except in relation to the American business. My lord asked a question about that, and in the response to the letter before action, we say that that was obviously a mistake. I mean, whether that's the case or not doesn't matter, but in a sense, those were what was being referred to. We've gone from that to a general case that we are seeking intentionally to do down these clients at the expense of some other clients. And what I say about that is that when you look at the necessary factual elements, the words where my learned friend said it was only knowledge, I'll come on to this very briefly in a minute, it's not only knowledge. They're alleging a deliberate act to do something. And the reason they're doing that is that they consider that that will assist them in relation, no doubt, to all sorts of matters, foreseeability and so forth, when it comes to the recoverability of damage. In a sense, it doesn't much matter. They've put those words in, they're seeking to rely on it, they're putting them forward, and they are fundamentally different from what we've had going previously. That's a very long answer to what was actually rather a short question. But
I've forgotten what the question was.
Well, the point I was trying to reply to was that one needs to be a bit careful about using cause of action without understanding the particular context in which it's used in this field. That was the point that it was addressing.
Yeah, I think the question I was asking is specifically was this 108L, or
Yes.
subsequently became 108 in the latest version. Doesn't seem to me to be pleading a cause of action at all.
Well, it's perhaps we should look at it. It's in
Page 130, the core bundle.
yes. Well, I mean, picking up on your lordship's point, of itself, it's not plainly pleading a cause of action. It's on its face a particular breach as confirmed, but what it's saying is by its actions, and then assuming per the judge, that is limited to the forged transfer to Rouse, Rouse provided an authoritative public platform to routinely make representations to third parties that they own the entire business. For example, now, actually, if you think of this in terms of either breach or causation, that becomes very difficult. If it's a question of breach, they've already pleaded the breach of the forged transfer. I mean, assuming that what they mean by that is the preparation of the forged transfer without any knowledge by us.
What I would say is by its actions, I understand meaning the breaches that we've already pleaded. The acts which amount to breaches already pleaded.
Sorry, I'm just going to check one thing. Your Lordship, just give me a second. Yes. Well, in the answers, we don't need to go back to them. They've said in the April answers that they encompass by its actions effectively the whole of 107. So that's what they are intending to say on their current case. So by its actions, then including but not limited to the forged transfer, doesn't really help. Rouse provided an authoritative public platform. Well, if all that means is that we did public trademark registry, fine. If it means something different, it goes beyond what they've said already.
Well, the authoritative public platform must be referring to the registry. What other authoritative public platform could there be?
Well, my lord, I'd agree with that. But then, if one then looks at just the first of these paragraphs, for example, KD contacted Gulf. Gulf was interested in making the investment, and in addition to further investigation, prompted Gulf to make an offer. Gulf no longer owned the business trademarks or licenses. Sorry, GT no. As a result, Gulf did not proceed with the investment. That does appear to be related to the trademarks directly. There isn't anything saying that they actually looked at it and so forth. But then look at 7. KD and CD interfered with the deal, advising they owned the business would injunct him. What's that got to do with the trademarks?
As I understand, what's being said is that the CDs, the conspirator defendants, were going around to parties who wanted to deal with the claimants, saying to them, look, we own this business. And what the allegation is that your clients, by wrongfully registering the trademarks in the CD's names gave a platform and an ability for them to do that. So that's simply what I understand to be alleged.
Well, my Lord, if that's what the case is, one then, as it were, says, well, you had the ability to do it. Are you saying it was actually done? Your Lordship asked my learned friend whether or not anything had been done about the trademarks. It's in the bundles, but it's a matter of public record that the trademarks are still registered. The UK trademarks are still registered with...
Well, presumably at some point they've got to have it determined that the assignments were forged, and that seems to be is the relief they're seeking in this action.
Well, that's quite interesting, actually, because the original holdings is in liquidation. The trademarks are therefore bona vacentia, as we've pointed out in the letters. We've done this already in the letters, and so the idea that you could have a judgment of this court making a decision about a public register without any application and so forth raises questions of its own. But, my Lord, the bigger point in relation to causation is this. At its lowest, there are enormous and real issues about how the acts which were originally alleged against my clients lead to the enormous...
Those are all points that you can take by way of your defence.
Well, my Lord, my next sentence was going to be, the court will no doubt say we can have a trial about that. But, and this was going to be my submission in response to that, is that we are entitled to clarity as to what it is that is and is not being said. And with respect to the discussion you were having with my learned friends about whether the scheduled loss is or is not part of the case, whether or not this is or is not a pleading on causation or allegation of breach and so forth, it illustrates the difficulties that we are having.
There does come a point at which one has to say this is something which has been hashed out in front of a judge sitting as a High Court judge, and in a sense we're getting into the sort of detailed analysis of pleadings that I thought is not usually appropriate for one appeal.
But, my Lord, I accept that. Two points. There is, as I opened the appeal, an interplay between the new cases in green in relation to the new case and the case on causation. We wouldn't be here now if we'd simply got the original breaches and an intelligible plead on causation, and that's not happened. We've got this mixture of cases being put forward. And in relation to that, my Lord, the last point I propose to make by way of reply is just to respond to my learned friend's idea that he'd already pleaded, or sorry, that his predecessors had already pleaded, that we knew about matters, and that simply can't stand against what is pleaded at 129. Rouse repeatedly failed to communicate its knowledge of actions taken with the detriment and knowingly created a conflict of interest. That's J at 129. And then Rouse actively sought to advance the interests of KD to the detriment of their client and in conflict, including but not limited to, etc. Now, those are pleas of deliberate wrongdoing. They're serious pleas. They're against the backdrop of the claim form which I showed you, which originally had knowing assistance in it. They're against the backdrop of it being said, no, you're not a party to the conspiracy, but they're saying you're deliberately doing things wrong. And they are wholly distinct from the case which was originally put forward, which was plainly a case only in negligence with no requirement of any of that nature. And those matters, in my submission, as the passage from where my learned friend was reading out from from the decision in last authority he was dealing with. The paragraph immediately below. Sorry. Yes, the MasterCard paragraphs immediately below the paragraph that he was reading from says that in relation to limitation, there is a serious statutory policy involved in relation to this. One's not dealing with, to paraphrase your lordship's words, the sort of squabbles which ought to be dealt with by judges sitting as High Court judges. One is dealing with new allegations made long after the limitation which Parliament has said should not be made. And if that's right, then actually the interplay between the two in our submission leads only to one answer. Can I just turn behind me and see whether or not I've gabbled too much? No.
My lord.
Can I just ask, I've just noticed, it may have no significance, but paragraph L on page 130, the particulars under that jump straight from 1 to 7. I suppose we should be grateful for small mercies, but is there a... There is no missing 2 to 6.
I don't think so. I think it was one of the mysteries of the case.
It may just be a word processing.
Can I? Whose name?
Perhaps it's not really a question on your side anyway.
No. My recollection, now that your lordship has raised it, is that was always there. There was a glitch, and there was no explanation for it. Maybe someone thought better of something. I don't know. Okay.
Thank you very much indeed, Stuart. Stuart, Mr. Burns, we're very grateful to you and those with whom you've worked for the assistance you've given the court today. You'll be unsurprised to learn that judgment is going to be reserved. It will be sent to the parties in the usual way, only for the correction of typos. I can't imagine I have to repeat the warning that's contained in the Council General of Wales case as to the nature of the embargo. And we will do all we can to ensure you have a judgment sooner rather than later. Thank you all very much indeed.
Thank you.